right, sorry about the delay there. We'll go on the record now in our first case of the afternoon, People versus David Roderick Shepard, case number 235179 and 235180. The record should reflect that Mr. Shepard is present during the courtroom today.
Sierra Coke on behalf of the people.
All right, Mr. Shepard, this is the date and time set for sentencing hearing in this case. You're appearing before the court today without an attorney. You understand that you do have the right to have a lawyer present?
Yes, I do.
And that if you could not afford a lawyer, one would be appointed for you at public expense?
Yep.
You wish to proceed on your own, or did you want to have a lawyer present today?
Looks like I'll be doing it on my own.
All right. Have you had a chance to go through the pre-sentence report and review that?
No, I haven't.
You provided a copy of that? Did you get a copy?
I don't think so. Is it over here?
No. Mr. McDowell?
It was emailed to Mr. Shepard at the email address that we had correspondence to. I don't have the exact date, but I go look at the computer if need be.
Did you ever check your email?
Oh, yeah. I never received one, but does the court have the right email?
I don't know.
I have the email that we were corresponding with back and forth multiple times.
All right, so
I don't have
email,
I don't
the
have
email that you talked to Mr. McDowell on before?
Do you know the email so I can confirm it is the right one?
I don't know it off the top of my head. No, I mean,
Do you have an extra copy, Mr. McDowell?
I'll give my copy.
Shepard, we're gonna take a break for about 10 minutes. I'll give you a chance to review that report, okay?
Okay, sound good.
Yep, it's 1:36. We'll come back on the record at 1:45. record in People versus Shepard. And for the record, Mr. McFelda provided the court with emails that he corresponded with Mr. Shepard regarding the pre-sentence report. And Mr. Shepard, it appears you were mailed that report back on May 2nd to dbshepard15@gmail.com.
That's the incorrect one, and I've changed it 3 separate times in this court.
Okay, well, as of April 12th, you were communicating with Mr. McFelda on that email address. So
I have no access to that email.
did you
so-
tell him after that you had a different email address?
No, I corrected it at the front office, so I figured it would have got to him.
Who did you correct it with?
One of the clerks at the window.
What was her name?
Not really sure.
What date did you correct it on?
It was. Would have to say. Be my pre-sentencing trial. I guess whenever the last time I was in here,
When would that have been?
not sure.
All right, well, if you can't give me a date, then I'm gonna assume that we have the correct email address.
Okay.
And as of April 12th, you had responded to Mr. McFelda from that email address. And he sent it to you at that email address on May 2nd. So, did you have a chance to review that pre-sentence report?
Yes, I did.
So, the way that this works is you have an opportunity to correct any factually incorrect information that's within that report.
Okay.
So is there any factually incorrect information in that report?
You know, in that 10 minutes, I didn't get a really good look at what the report said, so I couldn't tell you if there's anything that was incorrect.
Okay, so you don't have anything to correct from that report?
Nope.
This would also be your opportunity to challenge the scoring of the guidelines. Do you have any challenges to the scoring of the guidelines?
No, I do not.
Let's vote. Do people have any additional solutions to correct?
No, and I believe it was scored properly.
Do people have any victims that wish to address the court?
Mary Elliott is present today. She does not want to speak. She did just have the victim impact letter that was provided to the court.
Okay, and for the record, I did review the victim impact statements, so I did have a chance to read that. Ms. Koch, anything on behalf of people for application today?
Jenna, we prepared for trial in this matter, and I took the video of Mr. Shepard that was taken from Miss Elliott's ring cameras, and I watched him come onto the property and literally just start smashing her property for no reason that you can see it all. He literally walks on, you hear a bunch of crashing, you can see him in the different cameras, just breaking things and then leaving. You know, the restitution amount in this case is $5,340. And I can't imagine that Mr. Shepard thought to himself the amount of damage he was doing to this woman's property, as well as her well-being and her happiness in terms of coming up here. She indicated she used to love coming up here. So I don't know what his motivation is to go to his neighbor's house and just start smashing things. And then, you know, it escalated into an RNO and stuff. Mr. Shepard's 29 years old. He has 3 misdemeanors. He seems to have problems with self-control. I hope that he's able to get them under control. Otherwise, we're just going to keep seeing him over and over. The recommendation here is for 90 days in jail with 13 days served and restitution of $5,340.96. I'd ask the court to follow the recommendation. Thank you.
No comment.
Do you have any explanation for why you did what you did?
An explanation? No, but I do have an apology or regretful. I am regretful for everything that brought us to this moment.
In the report, it says that you thought that that cabin belonged to you. Is that correct?
I did believe it belonged to me.
What in the world would give you that indication to buy it from somebody?
Did I?
Yeah.
No. I thought it was in my wife's name.
Okay. Did she have any kind of documentation to show that she owned that cabin?
Nope.
So what did she told you that she owned it, so that you decided to go?
I never seen any documentation on it.
So what
Yes, I
made you
just believed her.
think that you had the right to go on that property and do anything?
I would say nothing.
That Nothing. Ridiculous. Willfully destroys somebody else's property. With absolutely no explanation, no rational explanation. Doesn't make any sense to me. I was asking those questions because I'm sure Ms. Elliott would like some kind of explanation.
Right.
Apparently you don't have one. Apparently that's just the way you conduct yourself. I think given your record, which is minimal, you are, I think, eligible for probation. I think it's a reasonable step to take at this point. And I agree with that part of the recommendation. I also agree that some jail time is appropriate given the nature of your conduct and really the lack of any kind of rational and reasonable excuse for doing what you did. Destroying somebody else's property that clearly didn't belong to you. So the court is going to also impose some jail time. I'm going to hold some jail time in abeyance to see how you do on probation. Frankly, the way that you conducted yourself during the pendency of this case, I don't hold out a lot of hope that you're going to successfully complete probation. Maybe you will, that'd be great. But if you don't, I want you to understand that there's going to be additional penalties and consequences for your failure to comply with probation. And you're not starting off on a good foot. You know, this whole, I changed my email, but I don't know when. And I didn't get this PSI when clearly it was emailed to you at an email address that you were obviously using almost right up to the point that it was sent to you. Again, that's part of what gives me concerns about your ability to comply with probation. Lie about not getting an email. Clearly did or should have gotten. Be that as it may, we'll see how we do. As to file number 235179, which is the resistant obstructing charge, the court is going to sentence you to 90 days in the Crawford County Jail. You have credit for 13 days served. The court is going to order a crime victim's assessment of $130 and $68 state costs. As to file number 235180, malicious destruction of property, the court is going to place you on probation for a period of 3 years. The court is going to adopt as the conditions of your probation all the terms and conditions listed in this report. So it's very important for you to go through those with Mr. Valdez so that you understand all the conditions of your probation. Excuse later on if you didn't know or didn't understand. So whatever you need to do in terms of asking him questions to make sure that you're clear on all the conditions of your probation, you need to do that ahead of time. Because again, once you sign that order of probation, the court's going to assume that you know and understand all the conditions. The court is going to, on that file, order that you serve 180 days in the Crawford County Jail, 90 days of that up front, with credit for 13 days served. The court is going to hold 90 days of that in abeyance, served at the discretion of the court. The court is going to order restitution in the amount of $5,340.96 to be paid to the Crawford County Clerk, and dispersed to Latitude and Subrogation Services. Crime victim's assessment of $130, supervision fee of $30 per month while you're on probation, $325 in court costs, and $8 state costs. The court is also going to add to the conditions of your probation. It's already part of the conditions, your paragraph. It should be 21, which is you must not enter the property located at 11523 Hardin Road, Roscommon. The court's also going to add a no contact provision victims in this case. So you're going to have no contact either directly or through another person with this Elliott while you're on probation. You have the ability to seek an appeal of this sentence. And Mr. Trush, if you wouldn't mind, I'm just having showing Mr. Shepard where he's here now and see that those guys. Hey, could Mr. Shepard explain to you what your appellate rights are, as well as how to request a court appointed lawyer to help you? Remanded to the custody of the county at this time.
And Your Honor, I just want to place on the record, so Mr. Shepard's not surprised. If he violates a condition of the probation, he'll have a probation violation. But it's also an additional charge of aggravated stalking if he goes on that property, has contact with the victim. And I will have no problem charging that if he violates. I just wanted him to know so that it's not a surprise later.
All right. People versus Terry Johnson, case number 235233.
Sierra Cook on behalf of the people.
Thank you, Your Honor. On behalf of Mr. Johnson.
Record should reflect Mr. Johnson's present here in the courtroom today. True, so you're aware, I did receive a packet of documents on behalf of Mr. Johnson. I had a chance to review all of those documents prior to today's hearing. Number of character letters and support letters for individuals in the recovery community, as well as some lots of meetings attended and so forth. So I did receive all of those. Ms. Koch, I did receive request for presentation submitted by your office regarding this. Mr. Johnson, have you had an adequate opportunity to talk to Mr. Trish and go through the pre-sentence report with him? Yes, sir. Okay.
Your Honor, I did have additional character letters to the court.
Okay. Had a chance to review those, Mr. Chairman, you want those attached to the PSI?
Yes, Your Honor.
Are there any other additions, deletions, or corrections that need to be made to those pre-sentence report?
Don't believe so, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
I talked to Mr. Rick Falda about the recommendation in this case. I mean, Mr. Johnson, he's 63. He stands before the court on his 13th felony. He has 8 prior misdemeanors. This is his 5th and 6th operating while intoxicated. He's had 5 previous prison stints. This happened 5 months after he got out. His labs were 0.214. And the reason his guidelines are 19 to 38 is because frankly, he earned those with his criminal history and the choices that he made once this began. I think the recommendation is appropriate. He doesn't seem to be as strong. He had lots of letters in here, but when you just look at the facts, they're just bad. And I think the recommendation is appropriate. Ask the court to follow it. Thank you.
You need that, Mr. Kirsch.
Yes, Your Honor.
I'm not gonna step off your bench, just let us take a second here. Okay,
yeah.
back on the record. Anything for elocution?
Yes, actually, and I have quite a bit to say, but I wanted to start with, Mr. Johnson has indicated to me he had been released from prison for about 2 years before this had happened. He completed his parole, I think, about 6 months before this event occurred, just so the timeline is clear for the court.
Okay.
In regards to this case, I think this is probably one of the toughest cases to look at, and I don't envy Your Honor in terms of sentencing here, because I really think what we have is a lot of things that point in different directions. I certainly can understand, given the prior history and the prior alcohol-related offenses, why probation and parole would make a recommendation the way that they do. And as the prosecutor said, the guidelines are what they are because of what his history looks like. But I think there's another side to this. And Your Honor has seen the letters and the certificates and the proof of meetings that we provided to the court. Your Honor can see the courtroom is full of people from the recovery community who Mr. Johnson has touched since he's been engaged in recovery. So I want to give the court another timeline. So Mr. Johnson enters rehab 10/10 of 2023. He's an inpatient from 10/10 until November 30th of 2023. From November 30th until present, he's been an outpatient. The first 30 or so days of that were intensive outpatient, followed by a long stint of, continued stint of outpatient treatment. Since leaving the inpatient treatment, he's been in a sober living home where he continues to reside and has in fact done so well there at the sober living home that he's been offered a position to be a house manager at that sober living community. He's been attending AA meetings 2 to 4 times per day. He's chairing meetings, he's sharing. In the time since this has happened, he's engaged in recovery in a way that we see few people engage. I spend a lot of time in front of Your Honor, and we spend a lot of time dealing with offenses that are alcohol related. And I feel confident in saying the vast majority of people who come before you have not put the sort of effort into recovery that we're seeing from Mr. Johnson here. In addition to that, I've had an opportunity to talk to Mr. Johnson about sort of some of the things that are a little different for him now. And I mean, one of which is I think he's engaged in recovery in a way that is a lot more committed than he has in the past. But I think the other part of it is, in order for recovery to work, we have to get to the core of what the problem is, right? It's not just about don't drink. It's about why. Why do we repeat the patterns that we're repeating? And I think this is the place where I have the most sort of confidence and faith in Mr. Johnson. I've had an opportunity to speak to him, and he's disclosed to me some childhood traumas that I don't think he really has talked to very many people about until lately. He's working with a counselor. He's working through some of those childhood traumas that, frankly, I believe, and I think he believes, are sort of the root of this problem that he has. He's had a problem Your Honor can look at the record. I mean, he's had a problem with alcohol his whole life. He's got a criminal history that reflects that. I also think what he's done since this event, all the work he's put into rehab, all the meetings, all the testing, everything that he's done warrants giving him an opportunity. Roscommon still wants to take him into their sobriety court. I certainly understand why the Department of Corrections made the recommendation that they do. But I think we have an opportunity here to really change lives. And I would ask the court to consider allowing him the opportunity to continue on the recovery path. Where he's not just affecting himself, but he's affecting other people in the community in a positive way. And to allow him to engage in the recovery court, a program that frankly, through most of his criminal history, didn't even exist. That type of response to an alcohol-related offense wasn't even available to him for the vast majority of his life. So I would ask the court to consider giving him that opportunity. And certainly if he is not successful with it, we all know where that ends. But I think that what he has done since these offenses warrant the court considering that. Thank you.
Yes, my trouble started when I was 30. I started running away, breaking in, getting locked up. Why did I do that? I did that because I was adopted into a family. Johnson's family. Here, Johnson was a pedophile. When I reached out for help, I didn't get it. He was a constable in the area. Police department. He had children in his home before that. When he told these stories. Later on, but they wouldn't listen to me. Even later, convicted of child molestation and sent to prison. I continued doing what I was doing prior to that because I think I got to the point where I didn't know anything else. The drinking was my escape from the ignorance. And I continued to drink because that was my way to deal with it in my head. When I was drinking, nobody could see in my head. I've always felt that people could look inside of my head and see stuff that happened to me as a child. And for me, the way to deal with it, that's what I do. That's what Gary Johnson taught me to do his child abuse. I think by him over and over and over again. And I finally got a therapist who I talked to about it. I shared.
My members, my people, my family.
I shared with them. And I've become accepted in their family. And I don't want to give that up, not for anything. I asked this court to give me the opportunity. Sobriety. Hold a 36-month to 5-year sentence in advance over my head. If I should mess up, by all means, send me back. Because that's where I'll prove I belong. I don't believe that's. I believe that I need to be locked. I believe I need. I believe that it can show this court. What I'm saying here today. I made a commitment to serve God. I'm all this before. I serve you every day. I start my day out without asking for direction. And I ask him if I don't have the wisdom to understand the direction, at least let me do the next best thing in life. And so I find myself every morning after getting off my knees going to a share of those tables. I don't share in my life. You know, I can't ask you to do anything you don't want to do. But I'm hoping you can take all this into consideration when you post sentence today. I've kept in contact with Mr. Cruz. I've always gone all my life. When his recommendation was known by me, that was a carrot for the rabbit to run. But that rabbit didn't run. That rabbit stayed to face what he had coming to him. So that's his code. And post whatever finds that you want.
Thank you. Obviously, I read through the pre-sentence report, so I'm very familiar with your background, your history, the circumstances of the offenses in this case. I did receive all of those letters, with the exceptions of the ones that I read this here today. And I had a chance to review those prior to the hearing today. I spent a great deal of time considering what was the appropriate sentence in your case, because I think you have done a lot of good work since these offenses occurred. It's unlikely that as many people that have come forward to submit letters on your behalf would have done so if they didn't see something genuine about what you were doing in terms of your recovery. And so, I don't doubt that at all, that you put in some good work over the period of time here to try and get yourself on the right path. I'm sorry to hear about your trauma. I really am. I know that that is a big component in substance use disorder. I understand the correlation between trauma, in particular childhood trauma, and substance use disorder later in life, how it manifests. I'm sorry that you didn't get the help that you needed to deal with that earlier, because that may have helped you avoid some of what you did as an adult in your offenses. And those are all things that I view as what we call mitigating factors, things that work in your favor. There are, of course, things that work against you in terms of what an appropriate sentence here is. Your past history, you've demonstrated over time that you're willing to not only put your own life in danger, but other people's lives in danger, operating vehicles while you're not just intoxicated, but severely intoxicated. And I think it's fortunate in these particular incidents here and in previous ones that no one has been seriously injured or killed as a result of your choices to consume alcohol, which in and of itself, isn't dangerous other than to you. But when you consume alcohol and then it goes out on the road, but you're putting everybody else in danger. And when I try to balance what's gone on in your case, unfortunately, you have a much longer history and track record of putting people in danger than you do inappropriately dealing with your issues. And so while you've done good work, you're asking me to put everybody's lives in this community at risk. And what do I base that gamble on? Again, you've got a much longer track record of putting people in danger, and a much shorter track record of dealing appropriately. And at this point, I'm not willing to risk everybody's lives in the community on what's been good work, but what has been work of a very short duration in relation to your history of offending. And I would have a really hard time facing somebody later, having to explain to them why they work with below guidelines in this case, if you do mess up. At this point, again, given the short duration of the good work and long duration of bad acts, so the court is going to sentence you to the Department of Corrections. The court is going to sentence you to the Department of Corrections for a period of 30 months to 5 years. You have credit for 1 day served. Crime victim assessment of $130, court costs of $325, attorney fees of $350, and $68 state cost. That's as to the operating while intoxicated third offense. As to the operating while intoxicated misdemeanor charge, 93 days in the Crawford County Jail with credit for 2 days served. Crime victims assessment of $130, $50 state cost. Those sentences to run concurrent to each other. You have the ability to seek an appeal of these sentences. Mr. Trush, can you provide those acknowledgements?
Your Honor, I thought I was entering a plea, but I entered my plea to the fact that everybody was accepting of my sobriety.
That would be an issue for a motion to withdraw your plea. If you want to withdraw my plea, you'll have to file that motion later, and the court will put it in court.
My plea predicated upon such a thing.
Not as far as I understand it.
Prosecution talked to the prosecutor over, or Beth Zucker, who is the case manager of the sobriety court, and said that she didn't have a problem with me in the sobriety court in Ross County. And that's
That may be, that
reason.
doesn't mean that that's what your plea was.
Yes,
Then you'll have to file a motion, and the court will consider all the arguments, and the court will have to rule on that later. It's not going to stop what's happening today.
can I say goodbye to my friends?
You need to go to the officer right now.
Give this to my friends. Please. My bag right over here. There's a heart monitor which I have to have plugged in at night. And I was supposed to go in on the 20th, 24th for a heart procedure. And they're expecting me over there on the 20th. I hope this court can provide transportation procedure. I've had several heart attacks. I had a patient with a defibrillator. Got my medication.
The officers will help you take care of that.
Yeah, if they let me have it, I got it. Take my phone, they don't need it. Somebody knows where I am, send me some phone numbers if you will, please. Love you all. Thank you for showing up. Absolutely, buddy.
We're not Krista Piro.
So you're ready on Mr. Vickman's case?
Mr. Vickman is in the Otsego County Jail.
He should be, he was writted.
We're him from the Otsego County Jail?
My notes say he was writted.
And she does have a writ today for Zoom at 2:15.
Would Your Honor like me to call the jail in Otsego?
Yeah, please. All right.
Make sure he gets up. Yeah, I'm really glad you gave that.
Get it from Officer right here, and then another one. I said, I did approve him for civil report, then he got another, third habitual report, like the next week. Literally the week after I signed it.
Sure.
Colors come out and things like that.
So we guessed that.
What's that?
So there was a trial on Friday.
Oh.
Assume that.
Just record.
Rolling.
Vickman, are you able to hear me okay?
Yeah.
All right, we're on the record in People versus David Vickman, case number 204590. The record should reflect Mr. Vickman's presence today by video from Otsego County Jail. If I could have counsel for your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Vickman.
This is set for probation violation hearing today. Mr. Trush, is the defense want to proceed?
Thank you, Your Honor. I have an opportunity to talk to Mr. Haven as well as Mr. Vickman. Mr. Vickman would be acknowledging the non-technical violation that he violated state law. Specifically, he entered a guilty plea to child abuse in the 4th degree. I believe that was in Otsego County.
All right, is that a correct statement?
Yes, Your Honor. Count 2 is the violation of condition number 1, violating state law. The summons reads when he abused Cadence Vickman. And he did plead to see it for child abuse 4th in 46th Circuit Court in Gaylord.
All right, Mr. Vickman, is that how you want to proceed today, by entering a guilty plea to count 2 of the alleged violations?
Yeah. Yes.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Mr. Vickman, as you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yes.
And you understand that by pleading guilty, you're going to be giving up that right?
Yes.
And also by pleading guilty, you're going to be subjecting yourself to the maximum possible penalty on your underlying charge, which is up to 7.5 years. Do you understand that?
Yes.
With all those things in mind, what is your plea to the alleged probation violation today?
Guilty.
Anyone threatened you with anything to get you to enter this plea?
No.
Has anyone promised you anything other than what was said here in court today?
No.
Is it your own choice, free choice to plead guilty?
Yes.
Pleading guilty because you did violate your probation.
Yes.
On or about November 12th of 2021, so several years ago, but November 12th of 2021, were you on probation out of Crawford County?
Yes.
Were you aware that one of the conditions of your probation was that you were to not violate any laws of the state of Michigan?
Yes.
And did you admit to violating the law of the state of Michigan when you entered a plea to 4th-degree child abuse in the case in Otsego County?
Yes.
Right, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that Mr. Vickman did violate his probation as alleged. The court will accept the guilty plea. We need to set this for separate cases.
I think that would be appropriate.
That would be appropriate, Your Honor. The court would benefit from that.
All right, have you talked to Mr. Vickman about whether he wants to be changed?
I would ask that he be.
All right, so the court will set this for a sentencing hearing, Mr. Vickman. You'll be provided with notice of the date and time of that hearing. The court's also going to sign an order to have you transported here to Crawford County for that hearing, and you'll have an opportunity to consult with Mr. Truce, your attorney.
Okay.
Anything further, Ms. Koch, on behalf of people?
No,
Nothing further, Your Honor.
I did just want to raise, and I researched this before the sentencing, obviously. The court indicated the maximum penalty for his underlying offense was 7.5 years. I believe under the attempt statute, the maximum would be 5.
That's what I have, Your Honor.
And I served time on that too.
But
Okay, I was looking at second degree, which is 15. So.
the attempt statute caps it, I think, at 5.
Oh, it does.
Yeah, I'd have to double
I
check
mean,
that, but
I'll research it.
the PSI does indicate a 5-year max.
It doesn't. That's not going to affect the plea today, though.
No, I mean, frankly, I think his risk or exposure is less than what the court thought.
Okay. All right. Okay, Mr. Vickman, that's all for today. The court's going to go ahead and disconnect at this time. Thank you. I'm sorry. Okay. Are the parties ready on People versus Welch?
If we have a few minutes, please, Judge.
Let's take a 10-minute recess. We'll come back on the record.
Did you find him, Mr. Kern?
Yes, I believe he's on his way.
All right, we'll go on the record. This is People versus Brandy Welch, case number 235271. If I can have counsel for the opinions.
Good afternoon, Your Honor. Brendan Curran on behalf of the people.
May it please the court, Michael Nichols on behalf of Randy Welch.
We're set for a status conference in this case today, and then Mr. Kern, we receipt of ex parte motion to revoke.
Yes, sir.
Before we get to the bond issue, Mr. Nichols, can you tell me where you're at the defense side?
Yes, Your Honor. Mr. Curran tendered to me a written plea offer today, which changes the guidelines for Ms. Welch a little, but I need to really go through that with her so that we understand what we might be accepting or rejecting or maybe countering to. So we're not prepared to accept that offer today, but I do acknowledge receipt of that offer. I think I did make a motion out of concern about some discovery. I made it way back when we had this matter set. We had to return it a couple of times. But the crux of the issue is we don't have any body cameras. And when we looked at some photos that we had, I realized one of the officers had what looked like a body camera to me. That's why I inquired of that. And then the case went from one prosecutor's office to another. In the meantime, nobody really knows. Go to county prosecutor's office and say what the status is. There was some concern about this being one of the drug teams that may or may not wear body cameras as a practice. That's the latest I have.
Right, I don't see anything since the bind over or any kind of motion that's been filed with the court. So to the extent that you want to seek that, Mr. Nichols, obviously we need to be filed and sent for hearing. Okay, that's going to be an issue that needs to be resolved by the court. Mr. Kern, do the people take any position? It sounds like a request to adjourn scheduling today.
I don't object to that, Judge.
So, Mr. Nichols, this case has been bound over since November. I realize there's been a delay because of the prosecutorial issue. However, I will set this for one final status conference in 30 days. That will be a plea cutoff. So Ms. Welch will talk to Mr. Nichols, make any decisions about whether you want to enter into a plea offer, and any decision you make at that next hearing will be final. Okay. In terms of and Mr. Kern, in support of your motion to revoke the bond, is there anything further that you want to present to the court?
No, Judge, I'm perfectly content to rely on the written documents that were filed. Thank you.
All right, Mr. Nichols, your response to that.
Thank you. I did receive an email right around noon today, and of course, Ms. Welch had advised me that there was an issue with the test. The way I interpret the court rule is that the prosecutor proceeds under the bond rule 6106, which relates back to 6103, and the court is not left with just one option, which is put her in jail because the prosecution made a motion to put her in jail. Your Honor, I would request a hearing on essentially contempt of court. I know that, and I just had this last week in Ingham County. We're talking about methamphetamine. All I know is that there was an oral swab which was presumed positive and sent to a lab, but I don't know if that lab performed the isomeric ratio test that would distinguish, a version of meth that might be, we could say, is probably illegal use versus meth that's maybe acetaminophen or any of the other legal drugs. Ms. Welch brought to court today's medication that she took a couple of weeks ago because she was sick and it's got acetaminophen. So I'd like to get the opportunity to take the time, get a consultant to review whatever data I can get my hands on from the lab that did the so-called confirmatory test, and ask Your Honor to continue the bond for the time being, because the body of work, as the court mentioned, since the bind over in November, there have been no positive tests other than this one, at least not that I'm aware of. And Ms. Welch advised me that she went from testing multiple times a week. Now she's testing once every week or every other week. And I know I've got now a third communication from Jody at the agency where Ms. Welch is doing her counseling and treatment. And it's yet another positive update, things that she's working on, getting reunification with her children, getting more parenting time, custodial rights with her kids. And I've also got a letter from her significant other who lives with her, who reports nothing but positive change and stable lifestyle at this time. So my request is continue her bond. Let's set up for a hearing. And let me see what I can find in terms of defense to this confirmed positive. I haven't seen anything other than the collection data, and I think Mr. Curran attached the report from the lab that did the positive test. That's my request.
Is there any response to that?
No, Judge, I'm content to have you exercise your discretion. Thank you.
When was the last time you tested?
This morning,
Okay, you have the results of that test?
it was negative. I came here, but it was a negative test. It was here this morning.
I think I did get,
It's got to be in one of the ones I gave
right, the court is in receipt of Ms. Welch's test today, which indicates all negatives. In light of that, the court will continue bond. We'll set this for bond hearing at the same time as that plea cutoff hearing, about 30 days. The court will further address the alleged violation at that time. Mr. Kernan, anything further from your side?
No, Your Honor, I have nothing further. Thank you.
Mr. Nichols.
No, thank you.
Thank you. That's all for today.
Thank you, Judge.
Yeah, I gotta check.
Mr. Jaskowski, do you have any, do you have a client ready to go at this time?
I don't see those on here today. I am, it sounds like you're aware I'm going in today.
Right, yeah, okay. All right, we'll take a short recess.
Thank you.
So we have
People versus Sarah Trosper, case number 245294. Strasburg, can you come right to the podium here, please?
Yes.
Council, can you put your appearances on?
Sierra Cook on behalf of the people.
Dylan Jaskowski on behalf of Ms. Prosper. Mr. Boone, today.
Okay, Ms. Strasburg, do you have any objections to Mr. Jaskowski representing you for purposes of today's hearing?
No.
Mr. Jaskowski, how does the defense want to proceed in this matter?
Your Honor, it's my understanding that not too long ago, we had a preliminary exam in this matter. Mr. Gumuthi indicated to me that he has requested the transcripts from that preliminary exam, but hasn't received those yet, and would ask for 30 days from the date that he receives those to file any sort of motions in this case.
Well, we're not going to necessarily know when he received them, so if we set it out for 60 days, that probably is sufficient.
I think that's just case number one. Timeframe. So the court is going to set this for a status conference in 60 days. The court is going to order as part of the scheduling that if there are any pretrial motions based on that transcript, that they be filed by that 60-day mark. So we can Mr. Gerber, know.
Yes, Your Honor.
Any motion rising out of that would be Ms. Polk, any other scheduling matters that's filed today?
No.
Mr. Jaskowski?
No, Your Honor.
So Ms. Prosper, just make sure you stay in touch with your attorney and really.
Yes.
We're discussing case number 245296.
Sierra Cook on behalf of the people.
Dylan Jaskowski on behalf of Mr. Funk, just filling in for Mr. Funk. I did also want to advise the court that Mr. Funk does have hearing disability, so if you could just, when you speak out at the right. Your words. Thank you.
Can you hear?
Mr. Funk, are you able to hear me okay?
Yes, sir.
Okay. Do you have any objection to Mr. Jaskowski representing you here today?
Yes.
Do you have an objection to that?
Oh, no, I'm sorry. No, I don't. I'm sorry.
Okay. Mr. Jaskowski, how does the defense want to proceed?
Your Honor, Mr. Gumuthi has indicated to me that he was just waiting on some documentation from Mr. Funk in this matter. I believe that Mr. Funk is just able to get that to him either today or in the next few days. We would ask for just a brief 30 to 60-day adjournment in this matter.
Oh,
Your Honor, I would not object to a 30-day. We made the offer in March. We had a felony pretrial on 3/12. He believes he had a valid prescription. He's going to reach out to the doctor. It was adjourned 30 days at his request. Then we came on 4/16. It was waived and bound over. Still dealing with those issues. So I think if we had another 30 days, we should probably get it resolved.
okay, so Mr. Funk, the court is going to set this for another hearing in 30 days. Make sure that you stay in touch with your attorney, okay?
Okay.
And then Mr. Jaskowski, that hearing in 30 days will be a plea cutoff. So Mr. Gerber, you will need to talk to Mr. Funk and be ready with the decision on it.
Yes, Your Honor.
Mr. Funk, do you have any questions?
No, sir.
Okay, thank you. That's all for
Thank
today.
you.
Mr. Funk, I need you to go to the jail to get booked and printed, because they didn't do that wherever you were arrested. So I just need you to go get printed. They're just gonna print you and release you, okay? But I need
Where do
you-
I go?
To the jail. Around
Just
this-
walk right out? Okay.
Yeah, yep, but I need you to do that today if you can, please.
Okay.
Thank you.
Okay, so we're still waiting for Mr. Seeger on the Alex matter once it's ready to get started.
And he left Calcasieu at 2:46. He sent me a message.
We're on the record in People versus Alexson, case number 235248. The record should reflect Mr. Alexson's death.
Spherical could be after the people.
Thomas Seeger, apparently on behalf of Mr. Alexson. William Alexson, defendant.
The date time set for sentencing in this case. Mr. Alexson, have you had a chance to go through the pre-sentence report and speak to Mr. Seeger about that?
Yes, Your Honor.
Mr. Seeger, are there any additions, deletions, or corrections?
No, sir.
Any challenges to the score?
No, sir.
Hope do the people have any additions, deletions, or
No, Your Honor. Your Honor.
anything on behalf of the people for allocation?
I think the recommendation is appropriate. It took us a while to get this case resolved. I think he's been doing well since, and the recommendation takes that into account. Guidelines are 0 to 11 months. Recommendations 30 days in jail with 3 days credit, 18 months probation. This is a methamphetamine case that was pled down to possession of less than 25 grams. He is currently under sentence in another county, has 1 prior felony and 5 prior misdemeanors, and I believe he has a pending violation. Thank you.
Mr. Seeger.
Your Honor, and as the court is aware, this is just a small correction. He's already been sentenced in Kilkasson County. But to that end, Your Honor, I've known William for some time, and I think when I had first met him, he was struggling with addiction. Unfortunately, as the court knows, having been a Supreme Court judge at one point in time, understands that addiction can be a horrible thing. In this case, William has taken corrective measures to address his addiction. He has been regularly attending any classes, so he's been addressing his online problem. During the course of his probation in Kilkasson County, he had done reasonably well. He had been going through counseling, going to any classes. He didn't have any hot surfaces on his testing. His explanation in this particular case is that he thinks that the plate that was found that had residue on it was an old plate. The video, which the court may have watched, redacted portions of it because we had submitted it as an exhibit. The confines of his vehicle for which the plate was found and was quite messy. So there were a lot of different items that were strewn about in there. I don't know as if he was using it primarily because he didn't have any house or misses during the course of his probation in Kilkasson County. He's been trying to do very well with it, despite it being in there. It was just residue. I understand why the recommendation is the way that it is, and I can't say that it's generally unfair. I would just ask the court to consider giving him probation with some time of jail held over his head as opposed to losing it currently. To my understanding, currently Mr. Alexson is working at a trailer park for which someone has an interest in it, where he's trying to support his family. He recently became custody of his children, 2, 7, and 10, so he's generally responsible for those children. If he were to do some period of jail, it would make it difficult in terms of work, make it difficult in terms of continued custody efforts. It would just generally make it difficult. I think that Mr. Alexson is a good candidate for probation, primarily because he did do reasonably well on probation in Kilkasson County, and Mr. Hitt was his probation officer during that time period, despite being a probation officer here. And I think part of the reason why jail is recommended in this particular file is because he was on probation at the time that this occurred. But be that as it may, Your Honor, I think he is very much informed. He does want to address his underlying substance abuse problem. And to his credit, I think he's done very well on his probation, despite being unsuccessfully discharged through Kilkasson County. I don't want to disincentivize him from his continued recovery. I don't want to put him back further. If he wasn't engaged in NA counseling regularly, if he wasn't involved in counseling regularly, if he wasn't employed, if he wasn't making a good faith effort to try and better his situation, maybe the court looks at it differently. But in this particular case, I think Mr. Alexson has demonstrated that through his testing, because this case has been open for a long time, that he hasn't violated the conditions of what purportedly the court would do in terms of giving him probation, that he is taking it seriously. And if the court accepts to a certain degree that maybe it's possible that the substance that was found within his vehicle was an old substance that he just didn't recognize was on there when he was there. I mean, he wasn't charged with operating under the influence or something of that nature, or they found that system. He wasn't charged with something related to drugs in his system. He didn't have a bunch of hots or missed tests. When I had spoken to Mr. Haven some time ago, I had asked him, you know, how is he doing with this testing? Is he passing it? Is he taking it? And Mr. Haven had indicated that it had taken past them all, which is definitely positive. I guess to the extent that the recommendation calls for 30 days in jail, followed by 18 months of probation, the court were inclined to give him 18 months of probation with a larger amount of jail held over his head. Maybe that would suffice in terms of the punishment for him. Unfortunately for Mr. Ellison, part of the punishment for him is that he has an additional felony on his record, which is highly unfortunate. It doesn't make it any easier in life once you have one felony, but at least two. Certainly it's not a favorable thing. I suspect that if ever he should come back to the criminal justice system, he charges the individual offender and then hard problem for him. But I don't generally find Mr. Ellison to be a bad person. When I had initially met him, and this goes back to Kilgore County, he was trying to regain custody of his children. He's worked towards that. He has regained custody of his children, so it's a positive reflection of how serious he's been taking patient and he's trying to work forward. It's unfortunate that he finds himself in this situation, but I really don't want to set him back. He has called me on different instances where he's asked, hey, can you give me a ride, for which in some instances I have to come up and ride. So he wasn't support. I wanted to make sure that he would make it to court. He try and plan those things. Knowing I couldn't drive a vehicle or didn't have a ride or someone would cancel. Just trying to make a good faith effort to make sure that he wasn't violating any other criminal laws and just trying to comply with his probation and his conditions of conduct. So to that end, Your Honor, I don't know what quite else to say. I guess I'm somewhat rambling, but I just want to express that our country, as far as I can tell, has tried to make a good faith effort to change his lifestyle. And I can tell just looking at the pre-sentence report that there have been moments in his life where he's clearly struggled with substance use, but maybe this is one of his life change things. And because he did reasonably well in his probation to Kilgore County, with the exception for 18 months or even if the court saw fit to give him 24 months. I think that he would successfully complete it. And if the court held that time in advance, that's all the more reason for him to complete his probation successfully, wherein previously, which I assume if the probation department did not make it successfully complete his probation, they would probably recommend a straight jail sentence for him. Give him an opportunity. I think in the report, Mr. Haven had indicated that he's been polite, he's been courteous, he's been punctual, he's been timely. He's done all the things that generally are asked of people that are not always done in the law section. But be that as it may, Your Honor, he's just asking for one final opportunity to at least have the opportunity to continue to maintain care and custody of his children and to continue on with his sobriety.
Thank you, Mr. Ellison. Anything you wanted to say today?
Everything my lawyer said was absolutely correct. I have been trying to change myself for myself and my family. It has been a wake-up call. I just don't want to I want to keep continuing to go forward in my recovery, my sobriety, for my kids, myself. And it would, I just ask you to please do as my lawyer said and do the probation with the jail sentence over my head. I have learned my lesson. I just don't want my kids to go through it again. And I am sorry to you, myself, my kids, court.
Okay. I did read through the report, so I know what happened in this case. Obviously, you know, you're with you generally, Mr. Ellison, your background is the Kalkaska case. And, you know, I think there's a couple of factors here that are compelling to me. Number one, you know, this occurred, I think, over a year ago, or close to a year ago. almost exactly a year ago, May of 2023, and you haven't had any issues during that period of time. You've tested negative. That gives me some assurance, that you've built up a year now of time, that you would be successful on probation. I also think given that a year's passed, jail time, and particularly a nominal amount like 30 days is not going to have a significant impact in terms of your continued compliance. I think what would have more of an impact is what frankly you suggested along with council, which is holding that in abeyance, so that hopefully you know that you've got a significant jail sentence that you would have to serve if you violated probation. And that would provide added motivation to you to continue to comply. And I think that's going to have more of an effect going forward than imposing a short jail sentence up front would. So the court is going to place you on probation for a period of 18 months. And I'm going to adopt as the conditions of that probation all the terms and conditions listed in the report. The guidelines do call for a sentence of up to 11 months. The court is going to impose a 6-month sentence. The court's going to hold that time in abeyance to be served at the discretion of the court. You have credit for 3 days served. So again, to the extent that you don't comply with probation, or you be charged with similar conduct over the next 18 months, addition to whatever penalties you might face for that, there's the 6 months in this case that you would have to serve. So again, hopefully that provides, to the extent that you need additional motivation, does provide some additional motivation. The court is going to order this crime victim assessment amount of $130, supervision fee of $30 per month while you're on probation, court costs amount of $325, attorney fees of $350, DNA testing fee of $60, and $68 state cost. You have the ability to seek an appeal of this sentence. Mr. Sigurd should be right there on the table. And if you just have Mr. Allison down.
You would acknowledge your seat and they turn a copy.
Mr. Halen, do you need to meet with Mr. Allison here today?
Yeah, I'll talk with him briefly after. Dismissed.
Approach. Thank you. Present. And should be seated there. Thank you. Is Mr.
refuse service.
McGee present?
Hi.
They refuse service.
Okay, well, deal.
And his wife. We'll go on the record, this is Robert Vineyard versus Holly White. Is it McGee? Yes. Okay. Robert McGee, case number 2411660 and 2411659. Reflect all 3 parties are present here in court today. This is set for a hearing on Mr. McGee and Ms. White terminating certain protection orders that were issued at the end of April. Each of these files. Mr. Vineyard, my first question is, are you asking to have these orders stay in place?
Yes, I am, Your Honor.
So I'm going to go through the ground rules with all of you here as we proceed so that you understand how to go forward today. Mr. Vineyard, because you're asking these orders to stay in place, you have the burden of showing the court why they should stay in place. So I'm going to give you an opportunity to testify under oath and tell me why you think these need to remain in place going forward.
Okay.
Then Mr. McGee and Ms. White will have an opportunity to testify and tell me why you don't think they're necessary going forward. Because Mr. Vineyard has the burden of proof in this case, he will have the ability to respond to anything that either of you have to say. The court's